All right, we're getting close. Give a few more seconds. You're almost there. All right, let's go ahead and close the polls. And Jerry, I'm going to give it back to you. What is the correct answer?
I have no idea. Let's click the clicker and find out.
All right.
E, all of the above. We'll get it. Okay, in this case, in all of these examples, an address actually may suffice as a legal description. Now, but we want to clarify a little further powers of attorney. Here we have an issue, Paula Principal's power of attorney refers to all my property. Is a specific legal description required? Now, this is not a poll question, so you don't have to weigh in on this one, but just think about it for a second, and we'll be right back. Okay, time's up. In this case, no, a specific description is not required. Where the principal intends to authorize the execution of instruments for any real property owned by the principal, no further description is required, not even an address. Now, if the principal intends in their POA to authorize authority just for a particular parcel or parcels, then those parcels must be described. But when that is the case, an address is sufficient. And it's interesting to note here that while powers of attorney are very strictly construed when it comes to the authority that's granted, for instance, the POA must specify that it authorizes transfer of title or conveyance or to encumber or to mortgage property. Those issues are strictly construed, and general authority to do all things that I could do is not sufficient. In legal descriptions, powers of attorney are more liberally construed. So in this case, an address would not be required. Now, moving on to a couple of caveats here that we want to be careful about when relying upon an address for a legal description. In this example that we're going to give you, we're going to say that we're dealing with a dissolution of marriage judgment whereby, let's say that the wife is awarded the property in the judgment, and the judgment says that the wife is awarded the marital home at 14 Green Street. Well, if 14 Green Street is one little parcel of property with a marital home on it, and that's all they own in that area, that's pretty easy to understand and pretty plain. But what if next to that little lot with a house on it, there's an unimproved lot that they own, and what if behind that there's another piece of unsubdivided acreage that they both own? Now the question arises, okay, does 14 Green Street cover just one of those three parcels, two of them, or all three? So in this case, it's not certain. So in relying on an address in a case like this, you want to be careful to verify that there's only one possible property that could be construed for that to apply to. And where no exception applies, let's go back to a deed or a mortgage for a minute where you cannot use an address. You do not want to ignore an instrument that attempts to convey or mortgage a property by an address. So where it's apparent your owner is trying to encumber or convey the property, you should not ignore that. Just because it may not be adequate for title purposes doesn't mean we don't have to deal with it. The same rule applies for easements. If it's apparent your owner has attempted to encumber the property with an easement, even if it's an adequate description, you want to make an exception for that or deal with that issue. Now, next we have another uniform title standard, 21.3. This one's fairly straightforward. It says here that a conveyance which describes the land only by reference to a previously recorded instrument without reciting the description set forth in the previous instrument is valid, even though the examiner must go to another instrument to identify the property conveyed. So here you have, let's say, a deed or a mortgage. And by the way, this applies to mortgages as well. The Uniform Title Standard says conveyance, but it also applies to mortgages. But in this case, if you have an instrument that the legal description simply says lands described in OR book such and such, page so and so. If that is an adequate description, then that is sufficient. So assuming that that book and page has an adequate description, it would be sufficient. And as we said, that applies to all types of instruments, not just conveyances. Now, the next uniform title standard is a little bit more murky, but we want to make a point with this. This is 21.4, and it says that if a deed contains a specific description of the property, and in this case, let's say by meets and bounds, then if it also has a statement of the acreage contained, then the specific description prevails over the statement of acreage unless an intent to convey a certain quantity is clearly stated. So the point to be made here is really that where you have a more general description, we're going to give you an example here in just a second, and you have a more particular meets and bounds description, the meets and bounds will control. The example here is that if we have, let's say, a deed that says the south half of lot 1, more particularly described as follows, but when you run out the meets and bounds, it describes the south half of lot 1 and the north 10 feet of lot 2. Well, you have to be careful if you're a title examiner not to overlook that. There may be a temptation to say, well, I'm not in lot 1, I'm just in lot 2, so I don't have to look at that. But if the meets and bounds covers 2 also, then that description does need to be dealt with. So the examiner must check the meets and bounds description when you have one. And again, the general principle here is that generally the meets and bounds controls over the more particular legal. But there is an exception to that rule. You won't run into this a lot, but you will see it on occasion, so we need to talk about it briefly. This is the Carson versus Palmer case. In this case, which was in the town of Tallahassee, oddly enough, there was a deed that said lot 6, town of Tallahassee, and by the way, that was a discernible platted lot that could be determined. It said lot 6, town of Tallahassee, more particularly described as, and then it said bounded on the north by a road, on the east by a plat, or whatever it was, and it described the boundaries. Well, unfortunately, the meets and bounds description described lot 9 of the town of Tallahassee. The grantee in the deed, and lot 9, by the way, was the description that they were intending to convey. The grantee in the deed argued that the more particular meets and bounds should control, that should be a good deed to lot 9. But the court said no, because the rule about the more particular legal controlling, the meets and bounds controlling, only applies when it's more or less the same property. In this case, since lot 6 and lot 9 were completely distinct, separate parcels, the court said that that description fails and the deed fails. So important to keep that exception in mind. Now we move on to a different concept concerning legal descriptions. This is sometimes called the rule of construction or the rule of monumentation. We want to give you an example of how this can actually be helpful to you sometimes in dealing with errors that can be determined to be harmless errors. And this has primary application to meets and bounds descriptions. I think we mentioned earlier that in going from point to point in a meets and bounds description, basically 2 bits of data are required. You have to know the angle or the bearing, because you have to know what direction you're headed in from whatever point you're running from, and then you have to know the distance. And so in this rule of construction, we deal with errors that sometimes come up in that data. We'll give you an example here. We're just going to take a part of a call in a description here and describe how the rule of monumentation or rule of construction can help you in a case like this. The call we have here is Vents run north 89 degrees 05 minutes 15 seconds east along the north right-of-way line of Liberty Street. And let's stop right there. So this is the angle or bearing that we're going off to begin this point in our call. Well, you notice that there are actually 2 bits of data there for the angle. One is north 8905 15 seconds east. The other is along the north